Good afternoon. Thank you for being here. I am Sherry Boston, and it is my honor and privilege to serve as DeKalb County's District Attorney. But today, I'm here as a Georgian, a resident of the city of Atlanta, and a voter who is deeply concerned about the actions of lawmakers here at the state capitol as they try to take our power away in the voting booth. I am pleased to be joined by my colleagues, Clayton County District Attorney Tasha Mosley, Fulton County District Attorney Fonnie Willis, and Cobb County District Attorney Sonia Allen. I am proud to stand with my DA sisters to announce that later today, I will file a lawsuit in Fulton County Superior Court challenging House Bill 369 as unconstitutional. As you know, this new law changes local county elections from partisan to nonpartisan in Clayton, Cobb, DeKalb, Fulton, and Gwinnett counties. This means that when voters go to the polls, they will no longer see a D, Democrat, or an R, Republican, next to the names of the candidates asking for their votes. This change impacts us as district attorneys, but it also affects other county elected positions, including tax commissioner, clerk of court, and solicitor general. Republicans here at the state capitol claim this new law is supposed to take the politics out of local races, but we know the truth. Republicans here at the state capitol only want to take politics out of the equations in counties where they do not have a majority. There will be no changes to the ballots in any of Georgia's other 154 counties. Republicans here at the state capitol want to make it harder for voters in our counties to choose the people who best represent us and our values. But today, we are here at the state capitol to tell those lawmakers that we will not shy away from speaking up for the people of Clayton, Cobb, DeKalb, Gwinnett, and Fulton counties. The legal challenge has three main components. Count one, violation of Georgia's uniformity clause. The Georgia Constitution requires that laws work the same way throughout the state, and it prohibits lawmakers from enacting local or special laws that change the rules for just one area of Georgia. The Georgia Supreme Court has repeatedly held that laws that target just one or a handful of counties are unconstitutional. Count two, violation of the Equal Protection Clause of both the Georgia and the U.S. Constitution. Both the Georgia and U.S. Constitutions mandate that laws must protect all people equally. The legislature did not give any legitimate reason for treating our counties, our elected officials, our voters different from the rest of the state's 154 counties. They claim they choose the 5 metro Atlanta counties because we have no medical examiners, because we have medical examiners instead of coroners. But there is no connection whatsoever to the need for nonpartisan elections. And it is very hard to ignore that the 5 counties targeted by this law have large Black voter populations and have all elected Black female district attorneys. Finally, count 3, violation of Georgia's rejected bills clause. Under the Georgia Constitution, bills that fail on the House or Senate floor cannot be proposed again during the same legislative session without the approval of 2/3 of that chamber. In March, the state Senate voted down Senate Bill 573, which was an almost identical nonpartisan county elections bill. Just days later, senators on the Ethics Committee gutted House Bill 369, a bill about food trucks, and inserted the nonpartisan election language to bring their dead bill back to life. The full Senate never held a reconsideration vote, and the bill did not pass in that chamber with a 2/3 majority. This statute is clearly unconstitutional, and we believe it will be struck down. As the longest tenured DA in this group, I am honored to lead the charge on behalf of the nearly 4 million Georgians who live in the 5 affected counties. I want to thank our litigation firm, Caplan Cobb, for representing me in this fight. We hoped we would not be here. We shared our concerns about this proposed change at every step of the way. When Republicans first introduced the first version of this bill in February. Again, when Republicans snuck it into another piece of legislation in March. And finally, when Republicans voted to send it to the Governor's Brian Kemp's desk and he signed it into law in May. We hoped Republicans would listen, but instead they chose to ignore us. I have been clear all along about my plans to file a legal challenge if this ill-advised legislation became law. And today, I'm making good on that promise. To the voters of Georgia, especially in Clayton, Cobb, DeKalb, Gwinnett, and Fulton, I want you to know that I will always stand up for you and your rights. Your voice and your vote matter, and I will do everything in my power to stop those who want to give you less based on which county you call home. Thank you. I have time for a few brief questions.
Madam DA, good afternoon. Can you talk a little bit to why the Gwinnett DA isn't among you today? Because I know she shares the same concerns, and obviously she's also affected.
Yes, absolutely. As we know, this law unfairly impacts voters in Gwinnett County, as well as Clayton, Cobb, DeKalb, and Gwinnett, and she is absolutely in favor and support of this litigation, but she serves on the board of the District Attorneys Association and wanted to make sure it was very clear that there was a separation between that and this lawsuit.
Just one other question about the lawsuit itself. Are you the only named plaintiff, or are all 4 of you named plaintiffs? Can you just give us how that is going to play out?
Yes, I am the only named plaintiff, but we have all been united from the very beginning of this fight, and as a group, we made the decision that I was best positioned to take on this fight. I am the longest serving DA amongst this group, the longest serving Democratic DA in the metro area. I have filed a lawsuit against the state before, so this is not new territory for me, as you all know. So the group felt that I was well positioned to represent all the interests of all 5 counties and 4 million voters.
Madam District, address kind of that is the bigger issue of this affecting just 5 counties versus 154. Would, if asked in court, would you want this law for all 159 counties, or is it just reversing these 5? What would be the bigger picture around? Because that's the biggest question I've been asked by listeners is, hey, why just these 5 counties?
Well, you'll have to ask the Republicans why they chose just the 5 counties, especially because they could have made this for all 159. And at the end of the day, my goal is that if we're going to pass laws, we make it for 159, not just these 5. And if the legislature chooses to make these races nonpartisan, it should be everyone and not just Democratic DAs that represent the city of Atlanta.
Ms. Boston, does this law give a perception of what they think of voters, how they go to the ballot?
Well, I think the intent of the law, when you look at whom they've targeted, is very clear. They have chosen to go after Democratic strongholds where Democratic DAs and Democratic elected officials have been successful in these races. And it's clear, and some have been very open about their position, that they want to take politics out of prosecution. Well, if that's your goal, then that should prosecution is across the entire state. But that wasn't their goal. Their goal was to weaken the power in Democratic areas and make it easier for Republicans to get elected in places where Democrats have a very big stronghold.
Do you think they can argue that, well, voters will have to work harder to know who they're voting for?
Yes, voters, they will have to work harder to learn more information because they're stripping the ballots of information just in these 5 counties where they remain in other counties. And further, the most important thing we need to realize is that nonpartisan elections happen at different times. So they also are aiming to reduce the number of people that are voting in these elections. Smaller number of people and less education about races. We shouldn't be doing that. We should be making sure that every voter is the most informed they need to be, not strip information from the ballots.
Can you talk about this a little bit? Can you talk about this in terms of the overarching, in 2 weeks we're going to see redistricting, and we're also going to be redrawing district lines?
Absolutely. I think it's really important to note the times that we're living in, and the fact that the governor signed this bill on the eve of proposing a legislative session that's going to start on the 17th, which is to redistrict the lines in Georgia. Once again, trying to take away the votes and the voices of Democrats, of blacks, of voters in the state of Georgia. So I look at this lawsuit as another way that we are fighting back to make sure that 4 million voters continue to have the same type of political information and voice as the rest of Georgia, and they deserve that.
Do you feel that district attorneys are really the target of this bill as opposed to some of the other positions that would also be affected by this, or do you think it's kind of compliance?
Well, the first version of the bill was just district attorneys. After that, they started adding it in, but I think it's pretty clear that district attorneys have a lot of power in our individual jurisdictions. We are at the top of the chain of fighting for the rights of the people and making decisions that affect everyday lives. And so we're here to stand up and say, we're gonna fight back because we know that if we're in these positions, our voters put us here to fight for them, and this is exactly what we're gonna do. All right, thank you very much.